establish the need for the rule of law and separation of powers, and it came first from the 1215 King John's Magna Carta, which indicated that no one should be imprisoned or dispossessed or outlawed or exiled or in any way destroyed except by lawful judgment of his peers and the law of the land. I know that when I sat as a member of the bench that I would look at petitioners and I would hope that even though my history was that of a former slave, an African American, when I say a former slave, descendants of such, the history of African Americans are such. And I would hope that my background would not have countered the fairness that I was rendered to anyone who came before me. Judicial independence is something that we hold dear. The founders understood that judges who are able to apply the law freely and fairly are essential to the rule of law. The Constitution guarantees our rights on paper, but this would mean nothing without independent courts to protect them. That means our judges on the federal system should not be intimidated or influenced or protected from the influence of the other branches, as well as shifting popular opinion. This insulation is referred to as judicial independence. It allows our federal judges to make decisions based on what is right under the law without facing political, not getting reelected, or personal, getting fired, having their salary lowered. As a member of the Judiciary Committee, I have often joined with the late Henry Hyde, then the chairman, who wanted to raise the salaries of our federal judges. And so I think it is imperative to come before this body and my colleagues to raise great angst when someone's ethnicity is called out as a reason that they cannot be fair. I'm appalled that we have come to this in 2016, where if I was to ascend symbolically to a federal bench, or the colleagues that many of us have supported, and the Senate, as the President has nominated, the diverse bench that represents Asians and Hispanics and African Americans and women and men and Anglos, Caucasians, that anyone would raise a question. I've been before a court of which I have not welcomed the decision. There'll be many reasons why I was not pleased with that decision. But I could not raise the question of race. And so I think it is worth condemning that we would have this kind of public discourse where a race of a federal judge is raised. Remember what I said, judicial independence warrants that we in fact cannot intimidate the bench and not in fact deny the freedom of the court to decide cases based on facts and the law, not based on public opinion, the views of special interest groups, or even a judge's own personal beliefs. The right of every citizen to a fair trial is a cornerstone of our democracy. Why should anyone be diminished that, and why should the petitioner independently attempt to intimidate based on race? It is appalling and it is absurd. And so I'd ask all of my colleagues, as protectors of the Constitution and people who are here making laws, to independently go out into the highways and byways of life, condemn those words. Need I say who it is? Condemn those words and condemn this kind of discourse. And I would offer to say that anyone who has said those words, who pretends to put themselves forward to uphold this Constitution, is disqualified and unfit. And so I would hope that we will have an independent executive under the Constitution, an independent legislative branch, and of course, an independent judiciary, one of which I respect with the highest of authority. And I will close by simply saying, I won cases, saved a hospital, I have lost cases, I have been affected by cases in my redistricting and denied the rights under the Voting Rights Act, but I will never undermine and diminish the Constitution for right cases and wrong cases.
Gentlelady's time has expired.
I ask our colleagues to condemn those actions.
Chair recognizes the gentlelady from Florida.
I yield back.
Ms. Ross-Layton.